Sir, this judgment is by
Justice Nariman, Justice Sinha, and Justice.
Is there any judgment contrary to it?
No, my lord. As on date, my lord, I had, since I can submit at bar, my lord, that there is no on this count, my lord. On the contrary, I would be, therefore, I was saying.
It would have been better for you to say that you have not searched out for any contrary.
My lord, kindly.
It would have been better for you to say. Don't make a statement at the bar.
Or may I make a submission addition to it, my lord?
There is a contrary judgment by 3 judges bench passed in 2023.
My lord, kindly consider, my lord. This is a judgment on section 14 of moratorium. That's what my say is, my lord. This is on.
Yes, that is also a judgment on the same lines of the same bench. And you have made a specific submission that there is no judgment.
But to the best of my, I had edit.
It would have been better. It would have been better for you to make a statement, sir. You have not, or you could not lay down your hands.
Therefore, I had.
There is a specific judgment against you, and in that case, P. Mohan Raj was considered.
I wouldn't have since.
That is the difficulty. You people don't make researches and then start arguing the cases. अरे it was beyond reconciliation कि भाई वो सब बंद कर दो उठा के.
My lords are referring to a judgment in which it is.
I don't know. I am not supposed to tell you.
My lords,
sir, please. I have already told you there is a judgment of the same kind.
In that judgment, it has been said that section 14 will not apply to guarantors.
Sir, please. Sir, please. आपने judgment पढ़ा नहीं है और आप कहते हैं you are trying to distinguish it. How that is possible, yeah? That means you must have read that judgment and now you are showing your ignorance. If you have not read, then you can't make any distinction. And if you have read and you are trying to make a distinction, that means you have suppressed that fact that there is a judgment contrary to the judgment which you are citing. And in the subsequent judgment, the judgment passed in the case of P. Mohan Raj was considered. Fine. It was not my duty to tell you, but I have told you. That is all. Don't take it otherwise. I have told you. Otherwise, I would have written it in the judgment and fine. Sure.
May I humbly submit, my lords?
Please.
The issue is, my lords, that judgment which my lords are considering to be a judgment.
Sir, if you have not read that judgment, then please don't make a comment.
My lords, kindly.
Sir, please.
I am submitting, my lords. Let me be given a chance, my lords.
Oh, sir, sorry. I'm not here to tell you.
Then my submissions may be considered at least, my lords. That this is a proceeding, that the order of the motion.
No, sir, मैं कर तो रहा हूँ ना.
If I may make a submission that I would be at my lord's hands to.
Sir, you have already heard that once the proceedings have been initiated under IBC Act, then this proceeding under Section 138 of Negotiable Instrument Act would also be covered in the word of proceeding. Therefore, in the light of P. Mohan Raj, even the judgment passed by the trial court was nullity or it was not maintainable, and therefore the imposition of condition while granting bail to you, that is also bad.
I would add, therefore,
the
only issue which has to be added is P. Mohan Raj has considered section 14 of the IBC, wherein it has been against the company, and subsequently section 96 is a condition which is not available in section 14, and it includes the words proceeding. Section 14 doesn't include the words proceeding, my lords. It has been interpreted by the Honorable Supreme Court that it would be, but whereas section 96 is very specific, wherein interim moratorium applies from the date of filing till the date of admission, and from the date of admission, a 101 final moratorium would apply. Therefore, in that case, in that context, my lords, I had referred to the Punjab and Haryana High Court judgment, wherein specifically this distinction between P. Mohan Raj and
भैया वो दे दो यार 2023 वॉल्यूम 10 SCC मेरे को दे दीजिए. MCRC 17782/2024. This application under Section 482 of CRPC has been filed.